like to hand over the session to Chittaranjan Nayak sir as a chairman, and I'll come in between. Sir, it's up to you for discussing about the whole idea about this multidisciplinary colloquy and the speakers. Yeah, thank you, sir.
Thank you, Dr. Rajiv. Uh, Distinguished speakers, Professor Raut and Dr. Vidyadhar Maji. My learned colleagues who are online, research scholars, students, invited guests. So a very good morning to all of you, and warm welcome to my Department of Economics, Northeastern Hill University, Shillong. I'm immensely happy to welcome you all to this inaugural session of the Multidisciplinary Frontiers Colloquy organized by Department of Economics, Northeastern Hill University. This colloquy is planned as a monthly exercise. It will focus on frontier areas of research and policy with a strong emphasis with economics. The aim is to promote dialogue across disciplines such as law, technology, governance, and public policy. We begin this series with the theme of today, competition regulation in India, policy and perspective. Friends, in a fast-changing economy shaped by globalization and digitalization, competition regulation plays a key role. It supports efficiency, innovation, and consumer welfare. India's competition framework, based on Competition Act 2002 and implemented by the Competition Commission of India, in which my distinguished friend Dr. Vidyadhar Maji is the advisor. I will introduce him later. So, in Competition Commission of India, which has evolved over time, it now deals not only with the traditional anti-competitive practices, but also with the digital infrastructure, platform economies, and the data-driven business models. This calls for continuous discussion among scholars, policymakers, and practitioners. This colloquy provides a platform to reflect on important questions. How do we balance regulation with innovation? What are the challenges in merger control and antitrust enforcement? How should India respond to global developments in competition policy? So these are a few questions which remain to be explored and discussed in depth. This colloquy is important for that reason. So we are privileged to have distinguished experts with us today, and it is my proud privilege to welcome and introduce them. Let me first introduce Dr. Vidyadhar Maji, who is a distinguished economist and policy expert with over 28 years of cumulative professional experience, including nearly 16 years in senior positions at Competition Commission of India, New Delhi, where he currently serves as advisor for the economics wing. His expertise spans competition law, antitrust economics, merger control, which he is supervising now, and market regulation, with substantial contributions to policy analysis and enforcement. He has earlier served as assistant professor of economics at the prestigious Indian Institute of Foreign Trade, IIFT, New Delhi, and also a faculty member of University of Delhi prior to IIFT. So he has taught to undergraduate and postgraduate students at Delhi, His academic contribution includes 15 plus co-authored textbooks, research publications in reputed journals, and participation in numerous national and international conferences, including those organized by OECD, UNCTAD, and ICN. Dr. Machi has also delivered lectures at big institutions like JNU, IIT Kharagpur, and NLU National Law University, Delhi, and he has guided over 25 PG students for their dissertation works. So he has mentoring experience. His career reflects a unique blend of academic rigor, policy engagement, and institutional leadership. So, hearty welcome, my dear friend, Dr. Vidyadhar Maji, to my Department of Economics at the Northeastern Hill University, Shillong. Now I turn to my senior colleague, Dr. Chintamani Raut. Dr. Chintamani Raut is a highly accomplished legal academic with over 31 years of teaching experience, spanning from 1993 to 2024. So actually, he needs no introduction. He is very much our own. He superannuated last year only from NEHU, from the Department of Law. He was also head of the department. So he has taught a wide range of programs, including LLB, integrated law, that is BA LLB courses at NEHU, LLM, MBA, business law, and guided several students for their PhD dissertation. So his scholarly output includes 67 publications, comprising 5 research papers, 20 book chapters, and 2 author books. So, published in various reputed, peer-reviewed, and indexed journals. He has successfully guided 11 PhD scholars and evaluated over 60 doctoral theses for different universities across India. Additionally, he has presented research in 137 national and international seminars and conferences, demonstrating its sustained engagement with the global academic community. Professor Raut has held significant administrative responsibilities. As I mentioned previously, he was head of the department for over 9 years at NEHU, and he was, also handling charges of warden, and he was a governing body member of 3 affiliated for nearly 17 years. So this is, I'm also very happy to know that he was conferred the Rashtriya Gaurav Award in 2011. So friends, so we have got 2 distinguished, alumni, the distinguished faculty, policy, what you can say, advisors. So Dr. Machi has a good background in economics. Dr. Professor Raut is, he is from law background. So this topic is a mixture of economics and law. So I hope that it will be an exciting engagement. As I was introducing my department before start of the program, that NEHU Economics Department is a leading department in the country. Here we have 16 sanctioned posts. About 50 students are doing their doctoral research here. We have about 70 students in our post-graduation for first year, and second year it is around 140. So the faculty are engaged in several, research and consultancy activities apart from their teaching contributions. So I hope this will be an exciting engagement. Before I hand over the dais to my worthy colleague, Dr. Rajiv Sutrodhar, I once again extend my heartiest welcome to one and all. So looking forward. Over to Dr. Rajiv.
Thank you.
Thank you, sir. Thank you, sir, for this nice introduction to the department speakers and about the topic of the session. So I now am going to start the session, and I request first Professor Chintamani Raut to speak about or his reflection about the competition Commission and its policies for around 20 minutes before we move to the next speaker. Yeah, over to you, sir.
Fine. So, good morning to each and everyone present here through physical mode and also online mode. And a hearty welcome to everyone who is encouraging to this colloquium. And this is a topic, competition regulation in India, policy and perspective. Before that, I should extend my hearty regards to Professor Ponda, Bhagirathi Ponda, and Professor Utpal De, and Umdor also, and other colleagues also to the from the department, and the students of research scholars, and also MA students pursuing the course. So once again, I greet to the department also, as they have taken a hard task to perform every month, and they have chosen a topic also, competition regulation in India, policy and perspective, which is a very need of the hour. And it is not only to the students of law, it is students of economics, finance, commerce, and other students are also to be benefited out of it. And the department needs a congratulations, hearty congratulations to the department for organizing this and giving me an opportunity to be a part of this webinar. So beginning to the topic that, as I told, it is very important, and the present situation, it needs to see the policy and perspective also, what will happen in future, because we see the past also when we talk about the competition law in India, or the Competition Act 2002, and we find that Competition Commission is there, and the Competition Commission of India, CCI, which is very popularly known as. And going to the topic, before that, I want to give an introduction. When we talk about India, India has grown immensely from its British period to the present context. Because when we talk about the company, and it is the East India Company who came in 1600 AD, in 31st December, that was the milestone that came with a Charter Act from British Queen Elizabeth I. And they started the business here with a monopolistic. That word is very important, that because we have brought the act, it is MRTP, that is a Monopoly Restrictive Trade Practices Act, how it has came and how now we have reached to the Competition Act 2002. And thereby also we need today in 2026, we also want that more perspective, more new ideas, more situations are complicated. So as a student of economics, finance, and commerce, and policy makers, law students, now we need to contribute it to know what the exactly is. So I started with the East India Company, and they continued. And by 1857, that when Sipai Mutiny came, the British administration took direct administration, and they defunct this East India Company. But after that, we struggled to get independence. In 1947, we got independence. After that, our role started. And when India government looked to this economic situation, particularly the country as a whole, because we got a setback by partition of that Pakistan, and Myanmar also was also left before that. So this is the beginning of our real test as administrator. And when we talk about a constitution, we promise that welfare state we have to give equal justice and equal promotion to the all the downtrodden, so that this scheduled caste, scheduled tribe, women, children, and they need, because India was not that of a capability situation. Poverty was more, and trade, commerce, business has not flourished, and economic situation was not that much of good today what we have. So keeping in this view, that government find that very many companies are utilizing their own whimsical powers, positions, dominant positions particularly, to control over the other companies, other traders, other commerce. Because there is a saying, because when we rule a country, and we need a good administration, particularly not only the politics, but we also need economics for development. And economic is the bedrock and background. And we know you all the students are economic students, and how this Adam Smith, the father of the economics, has started with the point that it is not a economics, it is a science of wealth. So wealth has to be distributed, because we have added this constitution a fundamental duty, that we say the and also directive principles also we say, for the governance of the country we have to distribute equally the resources of the wealth of the country among all the people. Thereby we have to see the all the people have got the opportunity to grow and have their own self ways of living. But that has not happened in 1947 to 50. What the interim government find, that was difficult, and this, because as I told, it is not a jungle that where the might is right, that lions and tigers, they will eat away the weaker animals like deers and others. But that is not there. But or if it is a sea, you see that a big animal, big fishes, they eat out the small one. So that was the situation really, because the big companies, they dominated the positions. They did not allow others to grow, and they played unfair means. Unfair means you very little in a general sense you can understand that when the game or a play or a match starts, then discipline is important and rules of the game has to be followed. And it is a referee, and it is an umpire, or it is a arbitrator who has to do all these things. So in this case, when we find that something has to be brought by a law where we have to curb this menace of unfair treatment and monopolistic of a business, and not allowing the other people, because if you talk what is unfair treatment business, so unfair means which is not fair, which is not a rule actually true as per the rules of the game or rules of the economics. Because we say that when a product has to be there, so it has to be product with a quality. It is not the quantity, and if it a quantity there, quality has to be maintained. And in those days, now the Consumer Protection Act 1986 has come, whereby the government has made that who is a consumer, who is a producer, who what goods has to be sold, what nature of the manufacturing should be there, what is fair, and these are the terms were there. Indian Contract Act was there, and we were taking care of the agreement also. Agreement is very important, which both the MRTP Act and the Competition Act has taken care of. So agreement is very important, enforceable law, and which is enforceable law, because all agreements are not contract, because invalid contracts are there, illegal contracts are there, and the contracts can be void ab initio. So these are the principles behind which the legislators, they thought that we have to make a law whereby to, and not only law, because a commission has been appointed, that MRTP Act also provides one commission, that there's a monopolies destituted practices commission was there. So first the act was the 1969. But subsequently, we find that 69 Act, which brought to curb the menace of this monopolistic attitude of the companies, businessmen, traders, and because at that time also factories, industries has grown up. Because you see, as a student of economics, you find that when we started with our country, with the administration, and the responsibility that we have made a plan, and that time 1951 we started with a 5-year plan. And 51 to 56, 56 to 61. So these 2 5-year plans, we gave more importance on the agriculture and pasteurization, and a little about the industry and factory and all these companies, etc. But in a third 5-year plan, our planners, they thought that now we have to shift from agriculture to industry. And when industry was given priority, investment were there in a budget, we put more money on this to take care of the situation of the country. So that helped. But that industrial laws were there, that was the jurisprudence we followed, Factories Act, Industrial Disputes Act, and even that we have this labor tribunal also. But that could not taking care of these companies. We have Companies Act, but we have brought in 1956 Companies Act, you know. But that also, this again, directors and the managements were there. They are very clever, and they did not allow other companies to grow. So that was the unfair situation. So this MRTP Act, which has provided that a regulatory authority, that could not taken care of. So again, we have amendment in 72, 81, 82, and subsequently Sachar committee was made, and they recommended that now we have to go for, because you as a student of economics, you know more better than me, as because you have seen 1991 that globalization, privatization, and liberalization took place, and PV Narasimha Rao government was there, and thereby and our Manmohan Singh, he was the governor that time. He was appointed as a finance finance. So then a PPP mode has come. Public private and partnership has come. So these are the situations that gave rise to think of a new act, which the old act could not taken care of, because now the competition has given rise to in a large extent, and international competition has come. So keeping on these views, so from 1969 to 2002, so we followed this Monopolies Restricted Trade Practices Act, which are the same. Chapter 9 was there. Here also 9 chapters were there. 67 sections. Now here 66 sections. And structure-wise it is the same, but we gave more power to this Competition Commission under this act. So I am coming directly to the Competition Commission of India 2002, but it came in, it was assented by 13th January 2003 by the President of India. But this commission was really appointed in 2003, that Competition Commission of India, and it came into function actually 2009. Since then, we have not looked back. Now, though, we have find this Sir Vidyadhar Majhi is there. So he will give on light on this practical aspects, because he has joined as a head of this a combination division, because combination is one also the factor which was not in Monopoly Restrictive Trade Practices Act was there. So in section 5, section 6 in chapter 2 it is there. Sir is heading that. I have gone through this website. I find that so many the sections and divisions are there. As many as 21 divisions are there. In each division 4, 5, 7, 10 people are there, and he is heading where 5 people are there. So in this way, he has experienced a very practical knowledge on this as an advisor, and he will tell after me. But now I'm telling a structural and functional what the provision of the act itself has told. So the chapter 2 itself has already started with this function of the CCI and the appointment, establishment, composition of the CCI. It is a great one. It is just like you see Human Rights Commission, Women Commission, Scheduled Caste. So in other aspects, so this is a quasi-judicial body. We say in a Consumer Protection Act also we have the same provision that in district level, state level, national commissions we have in the same way, because if you don't keep one quasi-judicial bodies, and it is very difficult, you have to go to civil courts, and again you dispose of it takes time, because we have as many as 6 court cases are pending in the our original courts. So that is difficult. Keeping in that view, the legislators, they thought that we have to establish a competition commission, and the commission has to be chaired by one chairperson, and he is appointed for 5 years, and his term is for 5 years up to 65 years, and it may be 2 members, it may be 6 members maximum, but other organs are there, so many divisions are there as per the provision of the Competition Act, and the commission is excellently playing. Now the core is there. So madam is very excellent, and with a background, with a good background, she is heading, and a lot of many cases has arisen. And recently you see the mergers are there. Particularly Company Act was also amended during this period. 1956 Company Act now we have removed. Now we have brought that Companies Act 2013, because in Company Act we have a company arbitral appellate tribunal is there. So tribunal is important, because just like it is a quasi-judicial body, earlier there was a tribunal inside this Competition Commission where we are going for appeal from the chairman's decision or the commission's decision. But now it is a Company Law Act which gives rise, because there was amendment in 2017, and it gives a chance to this company appellate tribunal to look after these appeals from the chairman's decisions. But chairman has full opportunity and excellent powers with him, because he receives the complaint, and any agreements is vowed, and there is a nefarious means of indulging. So in one case in 2014, you will surprise that how this Amazon company and another farmhouse, so another powerhouse and Amazon company, they wanted a agreement where initially the company agreed, but later on the company found that foul plays are there, foul means are there, something has not been revealed, it is very concealed, and thereby they imposed a fine. When they asked the explanation, they could not, they imposed fine almost 200 crores. So in this way, the company is very active, the commission is very active. Commission role is important. Very experienced people, because when a person has to be appointed as a chairman or member of the commission, say they must have to minimum, as when the introduction was made by Professor Chittaranjan Naik sir, he told that how the other sir was also with experience. So like in the chairman, so 15 years minimum experience on the background of law, commerce, economics, or public policy. So imagine to that stature, if the people are appointed and they take care of the situations of because big companies you see involved with the crores, not only Indian companies, but also the foreign companies are coming. As I told, the multinational companies are interested to invest their money in our country, and our people are also going. So in this way, the mergers are there. Acquisitions and mergers now are very important things that is happening. Earlier, in company law, there was the mergers or the winding of the companies by the High Courts or the Supreme Courts. But now the Competition Commission is looking after the mergers acquisition. And many of the mergers and acquisition cases, you will find that and intention is not good, agreement is not valid, and the activity is also not fair. So unfair things are being happening. And you see, Consumer Protection Act is also simultaneously followed, and the individuals, customers, and the citizens of the country has to be protected. That is the aim and objective of the Competition Commission Act, and the role of the commissioner is very important. And they are looking after the fairness of the practice of the trade and commerce and the consumers' interest. Because unfair practice means something illegal rules has been followed, agreement has not been followed, production has not been taken care of, quality has not. So these are the things which are being basically compromised in the companies and the trades and factories and industries. That has to be looked into by the commission. And the commission is really playing an excellent role, and they are looking after, as I have told, many of the merger has recently taken place. That the HDFC with the HDFC banks. So there was a merger also. So that has taken care of on the basis of the advice, regulation, and the presence. And so it is one aspect, but another aspect is the individual can complain to the commission also. That is a quasi-judicial, and investigation power is very important. And the commission so moto can go for an investigation, inquiry, and they can ask for explanation, and they can take actions with penalties. That is one aspect. Another aspect, if any party is involved or any individual finds that there is a foul play and misrepresentation, particularly misrepresentation, that is a legal term, and where the truth has not been taken care of or the revealed. So in this situation, the commission plays a very important role, and the members are also helping. So I have 2 minutes left. Okay, fine. I am completing. So the most important is that legal aspect of this and economic aspect, economic development and economic fairness, as I told, and the downturners has to be taken care of, and the multinational people, they should not exploit the people by the name of the trading or business. So these are the main things where the Competition Commission has been established and playing a role. And now this, as I told, that the earlier MRTP Act has been removed, that is repealed, and but the commission also repealed. Only thing that the cases which were being filed before 2002, and these cases has been continued by this commission, because that is a legal transition that commission cannot deny. Because you may repeal a act, you may repeal this body which was taking care of the jurisdiction and authority, but Competition Commission is taking care of these cases which are being pending. Earlier, it is always legacy is continuing. So I thanks to the Competition Commission Act, which was brought into effect in 2003 by our legislator, our parliamentarian, and I thanks to the Competition Commission, which is working hard day and night, and all the members of those who are helping to the commission in different capacities, like our Vidyadhar sir, who is joined as an advisor in the Competition Commission, and a lot of many people are involved day by day. I surprised that so many experience and 100 people are there with maturity, with knowledge, they are taking care of. So I hope that economics will be taken care of in our country and will grow. And now we are the third largest economics in our world also. So in this way we are growing and we will grow further. With these few words, I give thanks again to all the people, those who listened patiently to me, I spoke something which you may not like to me, but I express my gratitude and thanks to the organizer, particularly Professor Chittaranjan Naik, all the faculty members who cooperated also, and the research scholars, and in specific, that Rajiv Sutradhar, who is the moderator of the today's meeting. Thank you, everybody. Thank you.
Thank you, sir. I mean, and thank you, Professor Chintamani Rao, for your insightful discussion. And your deliberation really provided the context about the transition from MRTP Act to this Competition Commission of India. So it provides the context for the Dr. Vidya Aji to now intervene. So over to you, sir.
So let me share my slide first. Is it visible now? Rajiv ji?
Yes, sir. Yes, sir. Yeah.
Okay. So, Professor Chittaranjan Naik, my dear friend and head of the Department of Economics, Northeastern Hill University. Professor Chintamani Raut, former head of the Department of Law, Northeastern Hill University. Dr. Rajiv Sutradhar, Assistant Professor. Distinguished faculty members and my dear student friends. A very good morning to all of you. At the outset, I'd like to extend my sincere thanks to the Department of Economics, Northeastern Hill University, particularly Professor Chittaranjan Naik, Chittu, for organizing this webinar on a multidisciplinary topic on competition regulation in India, and inviting me as a speaker. Indeed, it is a privilege for me to share my thoughts and experience with such a young, dynamic group of students, research scholars, and faculty members of NEHU on competition regulation India policy and perspective. Professor Raut has spoken a lot and really set the stage by introducing the background of enactment of the Competition Act. What I'll do, I'll rather focus on the regulatory aspect, practical aspect, application aspects, and what is going on in the arena of antitrust and merger regulation in India. Friends, in next 25 to 30 minutes, I just beg my pardon to Rajiv ji. I may take a little more time. I hope you will allow me, Rajiv ji.
No problem, sir. No problem.
Okay, thanks a lot. So I'll broadly focus on four areas in my presentation or talk. What I'll do first, I'll focus on the changing dimension of economic regulation in India. Of course, it has completely changed. We are in a different era, but from the perspective of, from the viewpoint of the students, of master degree students are there, research scholars are there, I'll give a perspective how the regulatory regime has changed. And then I'll focus on economic philosophy of competition. What are the economic principles? What is the economics behind the competition regulation in India? And how market power impacts the economy, the efficiency, and what are the regulatory approach? And how market power emerges due to agreements, unilateral conducts, due to combinations, merger, amalgamations, and acquisitions. And what is the role of competition? What actually the Competition Commission of India doing? What are the legal provisions for that? And finally, as Professor Chittaranjan Naik has said, there is a complete change in regulatory environment because of the emergence of big technology, platforms economy, and artificial intelligence. So what are the, whether we are really, India is really prepared, or whether what is the Competition Commission of India really doing to address, or what is the government of India to address the emerging anti-competitive issues in the economy. There I will end my presentation. So let me go to my first point: economic regulation in its changing dimension. Friends, what is regulation? Regulation is nothing but a sovereign conduct, sovereign activity of the government to control the private human behavior by prescribing a set of rules which has force of law. This is what simply regulation is. And to regulate, effectuate this through law, it can prescribe certain undesirable behavior, or encourage private people to comply with the relevant law. So for compliance, there may be incentive, or for prescribing certain behaviors, you can impose certain costs. This is what the basis of regulation, the very essence of formulation of law and regulation by the government. Since the functioning of the government is multidimensional, government can operate any sphere. It has sovereign power to operate in every sphere. So regulation may be multidimensional. We may say regulation, environmental regulation, if it is pertaining to environment, or if it is pertaining to any public interest, which public interest regulation, or if it pertains to any market activities, we just name it as economic regulation. Why economic regulation is necessary? It's just to tackle when the market fails to provide desired outcome, efficient outcome. It is just to prevent market failures, just to prevent anti-competitive practices, just to reduce market power, and just to make a balance between the unequal bargaining powers of different interest groups. Or you say balancing the power of different market forces, demand and supply process, as we commonly know in economics. So this is how the economic regulation operate, as the government intervene in the market when market fails to provide desired outcome. So far as the genesis of regulation is concerned in economics or economic regulation, we remember two prominent economists. One is A.C. Pigou, 1932, his book Economics of Welfare, where he has given what does this public interest theory says? The regulation is in response to the demand from the public, or the area where public interest will be satisfied. This is what we call as public interest theory of regulation in the name of A.C. Pigou. Another theory is promoted by Joseph Stiglitz in 1971 in his seminal article, The Theory of Economic Regulation, where he has given the theory of regulatory capture. That means, you know, that there are different interest groups, pressure groups are working, and they work for benefit of the members, and sometimes they pressurize the government to bring out certain regulation so that the members of their group, they benefited. We just, in a different language, we call it as a regulatory capture, which is contrary to the Pigovian concept of public interest regulation. Having said that, friends, I would like to link the regulation with economic models, economic development models. Basically, we know that theory in there are three forms of economic system operate. One is a pre-liberal market economy, we can say nowadays. Another, we can say a command economy, and of course, the mixture between two is the mixed economy. If the model is different, regulation is supposed to be different. In a command and control system, what we traditionally call is a socialistic system. The production activities, what we call the basic economic function, what to produce, how to produce, and whom to produce, is controlled by the government. When everything is under the control of the central authority, so regulation of private behavior is non-existent. On the contrary, if the economy is a capitalist economy, free liberal market economy, where everything is given to the private party to operate and provides to the citizens, then government cannot sit idle. There is scope that private party may exploit, may take benefit, undue benefit from the public. So there the regulation is sine qua non. And in a mixed system, partly the sectors or the area which are given to the private party needs is to be regulated, whereas the sectors or areas which are under the control of the direct control of the government, it is kept out of the regulatory things. Having said that, the most of the almost all the countries, they have somehow following the principle of liberal market economy, except bearing few, if we can remember. Let me link the economic system and the regulation with reference to India. During the pre-liberalization period, when we got independence, we adopted a state-led growth model. Mixed economy with more inclination to socialistic. Production resources were under the control of the government. Whatever development was taking place, it was under the guidance of the government. And this continued till 80s and late 80s, you may say that it could not yield desired result for the people of the country. The countries who got independence during that period, perhaps they were much ahead of us, if you say South Korea and many other countries. Their purchasing power, their quality of life, their standard of living is much better, were much better rather compared to the citizens of India. So it was felt, and it culminated into a huge economic crisis, balance of payment crisis, capital outflows, and the current account deficit that happened, and that culminated into new policy shift. New economic policy came in 1991. Privatization, liberalization, privatization, and globalization, see, became the fulcrum of development. So when policy changes, and rather we say during 3.5 decades, we are reaping the benefits of that. When policy changes, now the basic question is, what happens to the regulation? Would you will you continue to that old model of development, regulatory model, where government has everything regulatory model at that time, as Professor Raut has pointed out, MRTP, if you say MRTP Act, Industry Act, Industrial Development Act, Consumer Protection Act, and the regulation at that time was direct under the control. These institutions were under direct the control of the government, because the model was a state-led growth model. But now things have changed. We have a new system, new economic model, and the regulatory regime needs to change. And accordingly, you say after 1991, So many regulators, sectoral and cross-sectoral regulators come in the different arena, different fields, and they are acting, keeping a distance from the government. They are not directly government, but they have given some autonomous power. You say in 1992, the Security and Exchange Board, I'm just citing some of the acts, regulatory body came and a regulatory act enacted by the government of India since after 1991 liberal policy. SEBI 1991, TRI 97, and Central Electricity Regulatory Commission 1998, Competition Act 2002, PNGRB Act 2006, your RERA, Real Estate Regulatory, RERA came in 2016. Then so many others, higher education sector and so many other sectors, similar regulatory bodies are being visualized. So the takeaway point is that when the model of governance changed, regulation also changed. This is what my point on this economic regulation and its changing dimension. Let me, friends, come to my second point, economic philosophy of competition. Three points. I'll just focus on this three points. So if you have a liberal market economy, then the competition is the first order importance in the theory of state. Without competition, you cannot get efficiency, you cannot produce much output. And if you leave everything, if there is no competition, then ultimately, what is the objective of private sector? Why the private party operate in the market? They are just for profit. If there is no competition, there is less incentive for them to compete and to fight. And unless there is competition, unless they fight with each other in terms of market competition I'm talking about, then the best of market will not come. If you think of different sectors of our economy, you will be able to imagine that the sectors which are highly competitive, there the best outcome comes to the consumers. Consumers get best benefit out of it. Many things, the telephone and all other sectors, you just imagine what was the scenario where there was no competition and what is scenario now when there is competition. What sort of goods and services were available when there was regulation, government control growth, and what sorts of goods and services we are getting when there is open economy, open market economy. But its success lies only if there is competition. So competition is the most important thing in a liberal market economy. Without competition, will just create rackets. I'll use this word. And because the private sector people, they just will enjoy if there is no competition and there is no further investment is needed, no innovation, no technological development, nothing. So they will reap the monopoly benefits, monopoly profit, and they will enjoy their life by playing golf and other things. So if at all, if we want to harness the greatness of market economy, there must be competition. Then you can say, what is the role of the government then? What is the role of the government in a liberal market economy? The role of the government, just I'm coming to next slide, I'll back again, just to address the market failures. Economic students, you all are aware that these are the different conditions I have noted on my slide. Maybe externality, information asymmetry, market power, and public goods. If your neighboring industrial owner sitting on the top of the hill polluting your streams, it is the government to intervene, not any private party. If some neighboring country attacking us, it is the government to provide public goods. I mean, if we fight with each other, it is the government to provide the legal system, judicial system. If I'm sitting in the restaurant last evening, sitting in the restaurant, how can I know whether the kitchen has rats or the medicine I'm purchasing, whether it is counterfeit? So these are the different scenario of market failure. And when there is market failure, the government will intervene to eliminate inefficiency. If you see, these are the different 4 areas where government intervention is required. You see the market power is one of them. If there is market power, then government intervention is necessary. I'll come to that. And obviously, I'll just, since you are the students of, most of you are the students of economics, I must highlight only the competitive market can ensure efficiency and optimum social welfare. Be it allocative efficiency, reduce the cost for the end consumers, where price is equal to marginal cost of the product. Production efficiency, ensure cost should be the minimum average cost. The producer should sell at the minimum cost. It reduces the cost to the business partners. And dynamic efficiency ensures your research and innovations. So my point is, competition ensures efficiency. If there is less market power, more competition, and more competition means more efficiency, more output, more available to the public, and the better economic welfare. I'm just coming to my second point. But the problem is, there is a fundamental tension between stability and Schumpeterian creative destruction. Most of you know the Schumpeter, the creative destruction theory. Stability is bad in a liberal market economy. If any sector, if one player or many players, they are in the same rank, 1, 2, 3, 4 over the years, then there is some problem. That means no competition is taking place. No one is trying to outdo the others, outcompete the others. Then how the best will come? So stability should not be there. Every market player should live in a state of fear. I'm not in a state of fear, not that sense. State of fear means you know that you are number 1 today, someone, your number 2 and number 3 or some other one will come and take your place. Unless you innovate, unless you put your money, and unless you give best output at best prices to the people of the country. So there is inherent tension, and the stability is not good. That's my point is. And the third is the alignment policy with the principle of the competition is a desirable conditions. So the policy should be in coherence with the principle of a competition. So this is my third point. Sorry, the second point. Let me come to the market power. So what I say, the market power is bad. So market power, we are here just to address the issue of market power. That is what my point is. And the market power is nothing as a firm's ability to raise prices above the marginal cost. And these are the measures, you people know that. And we are also practically measuring the market concentration, measuring market power, be it Lerner index, be it concentration ratio, or HHI, hospital Hetzman index. These are the economic tools used to measure market power, whether it's a particular sector, a particular party, particular firm is enjoying market power. So the market power, if we segment the markets, competition, if there is profit competition, so market power is no, of course. And if there is monopoly, the market power is maximum. And in between, if it's monopolistic and oligopoly, you just take a call, what would be the in between, the market power is in between. And what is the role of competition? And how the market power will come? Market power may come. Market power may come due to agreements between parties. Market powers is not that inborn, market power ho gaya. It's not like that. It can develop over the years. It can assume over the years because of certain conduct. They may conduct in such a manner with a view to unfairly conduct in a manner with a view to assume market power, because market power gives monopoly power, and monopoly power, you know, monopoly profit, and monopoly profit is not, it's the price taker situation, and in the price taker situation, they will charge as much price from the consumer, and the output will be less. So the Competition Act regulates all these three things just to address the issue of market power. These are the provisions. Chintamani sir has already covered. I'm just highlighting two sorts of, I'm just dividing it into enforcement side for substantive sides, two provisions. One is ex post conduct and one is ex ante conduct, and on the other is advocacy and other related provisions, just to add something to create a competitive environment. In ex post conduct, a firm already indulged in a conduct, and the Competition Act gives power to the Competition Commission of India to prohibit that conduct by penalizing such party if they found indulged in such conduct. That means ex post. It is a legal mechanism. You can say the conduct has already happened. They have already entered into agreement. They have already abused their dominant position. And then a case comes to the Competition Commission of India. The commission will examine, investigate, and if found the parties have entered into agreement and to increase the price, reduce output, to allocate market, or entered bid rigging, or entered into cartelization, they will be penalized. And so far as the unilateral conduct is concerned, they also, if there is a one party which is in dominant position, it abuses dominant position, it will be penalized. Whereas there is ex ante also. Ex ante means the combination regulation is ex ante. Something may not happen. If you are A and B are merging, they are one and number one, number two player, and they will create a monopoly situation. We will object that. No, we will not allow them to merge, because it will create a monopoly, and monopoly objective is like that. So this is ex ante. And we have under section 49 and 49 section competition advocacy. This is just to spread the message of competition and spread the message of the create a competition culture. And whatever is there, it is ex ante or ex post. There are two. Sorry, on ex post, our analysis focuses on two modes. One is per se. Some conduct are per se anti-competitive. There is no need to prove anti-competitive effects, and certain conducts which needs to be proved. That means we have to prove that the anti-competitive effects outweigh the pro-competitive effects. Then only the penalty will be imposed. Agreements widely defined in the Competition Act. It is not that formal agreement. Someone has A and B enter into an agreement, they sign a paper. It is not just like that. It is one of them. But even a blinking of an, if two parties sitting together in a hotel room and they blink eye that tomorrow morning we will raise price together, then if it is recorded in the CCTV camera of the hotel, then it is produced before the commission. So that would be presumed, that would be assumed as an agreement between the parties. So it is widely defined. So all sorts of agreement, I mean the horizontal agreement and vertical agreements, are prohibited under the Competition Act. I'll just tell what is horizontal agreement and what is the what. But the measuring rod analysis, measuring rod of analysis is the appreciable adverse effect on competition. We have to see whether out of a conduct, and we are now talking about the ex post conduct, anti-competitive agreements and abuse of dominance. AAEC, appreciable adverse effect on competition, is the measuring rod we see. And in case of anti-competitive agreement, horizontal anti-competitive agreements, which is between different players operating on the same market, they are presumed to be appreciable adverse effect of competition. So it is a per se rule. It is covered under per se anti-competitive. No need to prove. It is not lies on the Competition Commission of India to prove that you have certain benefit. You cannot take plea that because of anti-competitive conduct, we promote such thing, promote that thing, that argument cannot be taken. Because it is presumed to have, you enter into price agreement, you enter into, you are operating in the same level. A is doing the business as B is doing, and they both are entering into agreement in relation to price, output, or any market development or technological development or bid rigging or collusive bidding, you will be penalized and percent competitive. And these are 4 things I've already spoken about: price determination, output determination, and limiting market, limiting supply, bid rigging. Anti-competitive horizontal agreement between parties operating same level. Vertical agreements, parties operating at a different supply chain, different levels of supply chain. Manufacturer, wholesaler, retailer, that the supply chain, and one is enter the agreement with the other. With respect to what? With respect to tie-in arrangement. You take this one along with this one. पेन ले लीजिए, पेन के साथ पेंसिल भी ले लेना. मेरा पेन बेचना है तो मेरा पेंसिल भी बेचना है. Exclusive supply agreement. I will supply. I will take my inputs from an exclusive supplier and just instruct the supplier, you will not give to others. I will take only from you, and you will supply only to me. Similarly, distribution agreement. You just tell your distributor, you only distribute my product, not the product of my competitors, unless it is your own. मान लीजिए आपका अपना है तो करो, कोई दिक्कत नहीं है. You cannot direct your retailers, wholesaler, that you will distribute only my product, not the product of my competitors. And someone, you are saying resale price maintenance. Resale price maintenance means you are selling X product, the car manufacturer is selling to the car dealer, giving a 20% margin, and you are saying you will keep 10% margin only, or to all its distributors. So that 20% margin, all distributors could have competed with themselves. Someone may give 10% to the consumer, someone give 5% to the consumer, someone may go to 18% to the consumer, keeping 2% of the profit if it is satisfied with the 2% profit. So these are anti-competitive, but this is considered on the basis of rule of reason. Rule of reason means, that means what is the anti-competitive effect, what is the pro-competitive effects. If anti-competitive effects outweigh the pro-competitive effects, then there will not be any case. So this is what vertical agreement is. And the next ex post conduct is unilateral conduct, abuse of dominant. This is one is agreement side, another is unilateral conduct. A particular company is in a dominant position or is a monopoly position. The act prescribes that if you are in a dominant position, then you have extra responsibility. You are supposed to not indulge some practices which will be considered as anti-competitive. The act prohibits abuse of dominant, but not dominance. This is a contradiction. I am just clearing the contradiction. Dominance is not prohibited in the act. आप monopolist बन जाओ. You like to be a monopolist, be a monopolist, no problem. But when you are a monopolist or you are in a dominant position, you have to conduct in such a manner that it will not impact your consumers and your competitors. Then it will be considered as an abuse of dominant position. The question may arise, similar conduct of a dominant enterprise will be covered under Competition Act, whereas similar conduct of a non-dominant enterprise will not cover. ये क्या बात है भैया? What is the logic? The logic is a balancing act. We are living in a liberal market economy era, and we want to spur our economic progress. And how the economic progress, how the businesses will operate unless there is profit. Towards the dominance, towards the monopoly, profitability will increase, and that will incentivize the producer come and produce more, which is good for the economy, good for the economic development. But simultaneously, when you reach, we cannot, in the name of development, we cannot allow the market power, unlimited market power. So that's why the things is taken that dominance is not bad, not per se bad under the Competition Act. Abuse of dominant position is bad. When you are abusing your dominant position, it is bad. What are the conducts? Abusive conduct, maybe exploitative practices. You are exploiting your consumers, imposing unfair price, imposing unfair condition, limiting, restricting production, and you can discriminated practices, and you can exclude your competitors from the market by imposing predatory pricing, or you are denying market access to the competitors, essential inputs to the competitors. These are considered as abusive conduct. So having said that, how the ex post inquiry taken place, just a brief review I'll just give. It comes to the commission. Any commission can, as Professor Rauta said, commission can also take sumoto cognizance, or any individual, any aggrieved party or any citizens of the country can go to the commission with a case. The commission will form a prima facie view. If no prima facie case is there, then the case is closed under section 22 of the 26 to 2 of the Act. If there is prima facie case, then the commission will send it to the DG office. DG will conduct, the Director General of CCI. It's a very it's a separated from us. It's an independent office. Will investigate and give report to the commission for imposition of penalty. Then CCI will consider the DG report and call the parties and give all the natural justice. Party will present their case, and if after the DG investigation is found that no conduct is found to be anti-competitive, the case will be closed. And if it is found that there is anti-competitive conduct, then the case will be initiated and party will be penalized. Monetary penalty up to 10% of global turnover is the power of the CCI. I'll just come to that one. So this is the exhaustive power of CCI, siege and desist order, imposition of penalty up to 10% of the global turnover, which is heavy. Modification of anti-competitive agreements. In case of abuse or dominant, the commission can order division of the enterprise also. And in case of merger, if there is appreciable adverse effect on competition, then that merger will not be allowed, so disallowed. And the commission has extra territorial jurisdiction. That means the conduct has happened in any part of the world, but its impact is on India, on the territorial markets in India, then it will be taken. Commission has the power to take under section 32, extra territorial jurisdiction. Commission can interior orders. It has the power of a court, and it can summon anyone to appear before the commission, and it can execute orders. It can direct the income tax to collect the penalties, and if someone contravene the direction, then commission can proceed under section 43 of that. The wide power has been given to the commission to contain the market power, monopoly power. So the next leg is merger control. The merger division I am heading now. So merger is ex ante things, and you know the so many merger, amalgamation, acquisitions are taking place in the economy, and it's good. Jitna acha hoga, jitna hoga, utna better. It's for good for the economy. Foreign investors are coming, and parties are also strategizing their business for economies of scale, efficiency gain, and so many other things. That is always welcome things, and we always that means the commission always encourage healthy competition in the economy and healthy merger activities. But there could be a certain scenario, as I highlighted earlier, that some merger or some amalgamation or some acquisitions may raise the concern of appreciable adverse effect competition. That means it may give rise to market concentration, market power. And if that things is there, then the commission has the power to block the merger or ask for the remedies. That is the most appropriate things. That means you cannot take this much, you cannot take this much, or you just strategize your deal in such a manner that you will enjoy the market power. That things also, that power is also there with the commission. So how merger notification coming to the commission? So the thresholds have been provided under the Competition Act. It is asset and turnover of the company. And recently in 2023, another thresholds has been provided just to catch the hyperscalers and big tech companies transactions. This is the deal value thresholds. 2,000 crore has been fixed as a deal value. If a particular deal is crossing 2,000 crore, then that has to be notified to the commission. And assets, there are 8 thresholds have been there, individual basis and on the basis of a group, and India and a global threshold. So far as individual parties to the combinations are concerned, if their asset, combined asset is 2,500 crore, compulsory file notice before the commission. However, all such thresholds have not been notified, are not required to be notified. Certain exemptions have been provided under the Act. De minimis methods means that if the target is very small, its asset is 450 crore and turnover is 12,500 crore, then such transaction supposed to not notify to the commission. It is exempted under the CCI minimum value of asset and turnover rules. Whereas certain other exemptions, suppose someone is doing only for the purpose of investment, it has nothing to take a strategic call or control over the other company. 14, 15 such type of exemptions are also exempted under such rules. And the government of India has the power under Section 54 to exempt certain things, such as regional rural banks have been exempted, and certain banking sectors companies are exempted from filing merger notification before the commission. The central government has the power under Section 54 to exempt certain sectors. We have a very unique system of just to for ease of doing business. We have a green channel mechanism. Green channel mechanism, if two parties are merging or amalgamating, or they are one is acquiring the shares, assets, and control of other company, which is a reportable transaction, and both the parties do not have any overlap. That means they are operating in it altogether different business. No horizontal overlap, no vertical overlap, no complementary overlap. They can file the notification before the commission, but on the day of submission, they will get acknowledgement, and that acknowledgement is approval. On the day of notification, they will get approval. So this has been done with a view for the ease of doing business in India. So merger regulation is mandatory in India, and it is suspensory. Once a merger is notifiable, the party cannot consume the merger unless they will have to minimum wait 150 days. Then only if the commission not give approval to them or not give go ahead, then they can consummate. Prior to that, they cannot consummate. If they consummate, then it will be considered as a gun jumping, and a penalty up to 1% of turnover asset will be imposed. For speech, I have much time, but I'll just highlight something on the policy change, and I'll stop here to take some view and comments, questions from the students and the faculty members here. So from the antitrust side, you know that the act, as Chintamani sir has emphasized, it was enacted in 2002. Then the Competition Act amended in 2007, drastic amendment taken. Then commission came 2009, and the substantive provisions came in 2000. Antitrust provisions, that means ex post provisions, came in 2009, May 20, 2009, and the merger came in June 2011. But if you see, these are at that time the you say hyperscalers and big tech were not that prominent. Platform economy not in prominence. The question arose whether the present Competition Act, because markets are now mostly tech-driven markets, and AI is ruling the roost. So whether the present Competition Act is equipped with all the tools to address the competition concerns in the AI market, the technology market. So considering that, the Government of India in 2023 amended the Competition Act, where so many provisions were brought, and just I have highlighted something. And from the antitrust side, exposed side, hub and spoke cartel, earlier it was not there. That means if a supplier is coordinating for cartelization among its suppliers. Suppose the main supplier is cutting the retailers, then earlier act, the only agreement between the party operating the same level were considered. Now, if someone is facilitating the cartel, that person or that entity will be also cut. And commitment and settlement, party have now, the government has given easiness to the party. If someone has at the prima facie level found that committed certain mistake, and the party is agreeable to the commission's finding, they can commit that I'll not indulge in such anti-competitive practices, and that things can also be accepted under commitment regulation. And even after DG find contravention, and the party can come that we will settle with the commission. That means we'll provide the settlement regulation is there. Party can settle their matters. So and the most important thing, the digital competition first ex-ante regulation is under process. It was there, the committee was appointed, a digital competition law committee, and for the ex-ante regulation. However, the government has now doing one survey on it by the ministry. It is kept on abeyance now, but the process has started to digital to address the issues in the digital market. So penalty also considered on the global turnover. On the merger side, deal value threshold was introduced. The objective was to capture the asset light. Suppose the big technology company, they are just acquiring the startups, and because the startup is a small one and it is used to have less asset, they were not falling under asset turnover threshold. So deal value threshold was introduced, and the review period earlier it was 210 days. Now it is reduced to 150 days. And the control, the definition of control, which is the basis of merger regulation, has been expanded, and it is expanded, and parties are allowed to purchase from the market. Then after they will come to the commission for getting a merger approval. So the commission is doing both excellently, doing both antitrust side as well as the combination sides. So many cases are coming to the commission on merger control and antitrust sides, and we are working for the economy. And we hope that there's a competitive, efficient economy will be great for our nation. Thank you so much. I'm just stopping here. Over to you, Rajiv ji.
Yeah, thank you, sir. Thank you so much for your insightful lecture. I must say I have really benefited from your talk, which I must say it's an eclectic mix of economic theories and your experience at the CCI. I'm sure the student community has really benefited from your deliberations. I myself benefited a lot. It cleared many of my doubts. Okay, so now session is like open for questions. Yeah, so I can already see some questions. Yeah, so but it's not written who it is meant to. So probably I can just read out the questions, sir, and any one of you can respond. So here's two questions. One, let me tell the name. Wang Hui Kibzen. In its role to ensure competition in markets, does CCI often experience
Your voice is breaking,
with respect to its ex-ante regulation, how effective is
Dr. Rajiv, the participant may be allowed
to you can read the question, sir.
put a question by himself or herself.
Yeah,
we can comment.
Yeah. Kibjan, you can read out. Yeah.
Okay, sir. So I have two questions. My first question is, in its role to ensure competition in markets, does CCI often experience regulatory overlaps with other government agencies that potentially impede in fulfilling its objectives? And my second one is, with respect to its ex-ante regulations, how effective is CCI advocacy in preventing market failure with respect to digital markets?
Okay, so so far as interconnection or interlink between the different regulators to address competitive anti-competitive practices. For competition, the CCI is the one and only one now. But having said that, you have valid questions. There are some areas where intersection of the competition law with other regulators happens. And in one or two cases, Supreme Court also directed the way for CCI and way for other regulators. And the line is, if it is the matter, it's a competition. For competition matters, the CCI is the sole authority to take a call first. Let us say in IP matter, competition on IP. In Ericsson matter, Delhi High Court directed that the first the issue involved IPR. So the IPR authority will decide the first, and then the competition authority. So the takeaway is, we have to find out a fine line between the issue of the issue, whether it is pertinent exclusively to the Competition Commission of India, it is pertaining to the competition in markets, then CCI has to take a call, or CCI to decide. If it is pertaining to other aspects, maybe just like say it is IPR, or maybe it is relates to telecom regulatory authority, or it relates to electricity authority. So there are certain regulations where till now also some sort of power is there. They cannot abuse dominance, is like that. Some sort of overlapping is coming, but in many times commission referring the matter to commission has power under section 21 can refer to the matter to other regulator also. So inter-regulatory coordination mechanism is there. But having said that, there is a clear-cut demarcation of a competition jurisdiction and the jurisdiction of other regulatory authority. And so far as big technology regulation is concerned, our act is equipped with that the anti-competitive agreements, abuse of dominant position, this is all are there to address the competition concerns in the any technology market. But the only thing is that I would like to, technology is fast changing. You know, in a year or two, the market position would change. So unless and until you are acting so swiftly, so fastly, then things will not be captured. But the mechanism of operation of CCI, so far as ex post regulation is concerned, you have to see the case, you have to find a prima facie opinion, you have to send for a DG investigation, you have to take the DG report, then the party can go to the different high courts for they can use their writ jurisdiction. So it is a time thing, and finally the parties can go to appeal the competition appellate tribunal, the national company law appellate tribunal, the appellate body. Then from there the party can go to the Supreme Court of India for a final decision. So when you are penalizing someone, the party will exercise its legal rights. We cannot say, and it will take time. So by that time, if a case linger for 5 years, 10 years or more, then it's really for market correction. Will lose. So that's why the government appointed a digital competition law committee, and the committee submitted the reports to the government, and it is under consideration of the government. Okay, any further question?
Pitnor, there's Pitnor, he has some question. Can you please ask?
Sir, can I explain that the first question to a little substantiate the student who asked that question? Actually, generally, it is in a general perception, it is always confusion and overlapping. To my mind, also as a student of law, also we see that suppose a consumer, when he affected, where he will go. So when the product has come to the market and a person has purchased as a consumer and with a price, so he will find out the defects with the manufacturing or date of expiry or the excess of price. So he can go to the consumer court, whether it is a state, district or national. So in that case, it is not overlapping, my student. So then you see when a company is being established, there are directors or a board of directors, how the company will establish, whatever their transactions, so that will taken care by the Company Act. So like when a factory, industry or farms are established, Factories Act there, labor law will take commission and labor tribunal is there. So these are the specific quasi-judicial bodies. So in case of a competition law, so Competition Commission of India is only and exclusively see that how the company after establishment, they are going to be merger and how they are producing the things, what are the agreements they did, what are the qualities of products they brought. So this is exclusively and clear from other quasi-judicial bodies, and CCI is clearly given that functions, power, duties to perform. So there is no question of overlap. It seems like overlapping, but CCI is very careful. People, companies are very clear, and they will go to that, and they will see how the merger and acquisitions will take place, and how these things has to be settled. So in that case, it is fine and clear, crystal clear. No confusion, please. Thank you.
Okay, sir. Thank you, sir. So now next question is, Pitnor has posted a question. With the change in governance, regulations also change. Why is it so?
Please come again, Rajiv ji. Just not. Okay.
With the change in governance, regulations also change. Why is it so, sir?
Not change in government regulation change. It is the policy change, development model change. Then the policy, then the regulation changed. So earlier we had a state-led growth model. We had that socialist inclusion model, 5 years plan, and a government to do everything for us. Now it is the private players, market will do for us. That is the things. When you have everything under your control, what really to regulate. But when you give everything to others, government cannot sit idle. Bhai, sab log kar lo, I'm sitting like, it's not like that. So you have to see the benefits of the consumers. So then only the regulatory perspective change or regulatory process change.
Okay. Is there any other questions, students? You can either post or you can unmute your mic and ask.
I have a question in the meantime. So thank you for the nice deliberation. Dr. Majhi, just a simple query comes to my mind that in this, in the age of digital economy, so some firms are having some sort of a data concentration. They have that advantage. And they also do have some sort of a platform dominance. So the query is that does the CCI have adequate tools to identify the market power in the form of a data concentration and a digital platform dominance? So is it potent enough to, identify and find out mechanism by which to regulate?
Yeah, good question. CCI is a cross-sectoral regulator, and it has wide spanning power. Any sector can operate. Just for the interest of time, I have just left out how the procedure for how ex post cases analyzed in the commission. So we have to see whether AEC is the cornerstone I already spoken about, but it is with reference to a relevant market. And the relevant market could be in the platform itself is a relevant market. So if we say for selling of consumer goods on a platform, then there could be Amazon, Flipkart, so many n number of players. Okay, so that aspect will be is being taken care of, whether it is a new age economy or it's a platform market or it's a traditional market. Relevant market definition takes care of everything. And so far as the considering it data, we also takes into account what is the capability. It is there under the act under section 19(7) while defining the relevant market, whether defining whether the company is a dominant position or not. The data aspect is also taken care of, like other factor of market share, resources of the enterprise, like all the financial aspect. There is I don't exactly remember, 13-14 parameters are there. And we are also considering if some digital enterprise having huge data advantage, then that can also be considered. And in many cases you will find in WhatsApp case, in Google case, that tool has been used. So it is there. The only lacuna, as I pointed out, the current regulatory process is a little time consuming because of the inherent mechanism there, investigation, judicial system like that. It is taking time and may not timely address the concerns in the digital economy. But there is no lack of any tools. The competition, modern competition act, it has everything as should be there under a modern competition law all over the world. So it is there, and in appropriate cases, it is also taken care of. Am I address the question, Chitawai? Thank you.
Yeah, thank you. Thank you. Rajiv, we can
I have two questions.
go
So
towards
one
the
one
concluding.
clarificatory question to
Yeah, yeah.
Professor Sintamani Raut. Sir, the question is, sir, you said this the cases under MRTP is still handled by MRTP or is it CCI? I am not little confused about that. And second question to Dr. Mazi, it is about, sir, like as I can see, the Indian industrial structure is kind of top heavy. I mean, and missing middle. So, what is your reflection as a CCI advisor on that? Yeah. Yes, sir.
So whether I will
Sir,
answer
yeah.
or sir will answer?
Sir, first answer,
Yeah,
I'll
the
then go.
first question to Professor Sintamani Raut and
It
second
is
question
simple.
to
You see, when the Indian Constitution came into force, we have established a Supreme Court of India, and before that, we have a federal court. And that federal court was just subsidiary to this Supreme Court of India carried through. The cases which have been filed before that 1950, 26th January. So what will happen to the parties, those who have in the Supreme Court and other courts? So it is general way that court goes on. The judges, they left, the name of the court changed. Instead of federal court, we just give another the signboard that is the Supreme Court of India. In the same way, when we enacted this MRTPC Act, so 1969, it continued, cases filed, and the MRTC commission has gone. Now, instead of that, we brought a Competition Commission of India. So it is his duty, natural duty, the cases which are pending before that, that will carry forward, and that will be looked into. They say now we have brought BSN, BNS, or that Bharatiya jo Nyaya Sanghita. So IPC has removed, but the cases are pending in the courtroom. So what the parties will do? Their cases will taken care of, but the cases will taken care of as per the IPC 1860. But now BNS has come after 2024 July. The cases which have been filed in the court will take care of these cases under the BNS. So the same principle is there. It is a legal principle. The parties should not be frustrated under they have to give injustice. That was the natural justice.
Just to add, since I was there
Yes,
in
yes,
the
yes.
commission
Sir, you can
in
add. You can add.
2009, all cases of MRT came to the commission, and initially there are no antitrust cases because commission was new. We used to do all the MRTP cases. So it is natural that all the MRT, and there is a provision in the act, all the pending cases of MRTP commission will transfer to the Competition Commission of India, and the Competition Commission of India has decided all those cases. That, what is your second question? Can you repeat, Rajiv ji?
Sir, what is the reflection on, like, say, like Indian industrial structure is now kind of top heavy and missing middle. So as a CCA advisor, what is your thought on that?
It is not that in India context it is like that. In any economy, any sectors, if you see, there should be some players which are supposed to outweigh the others. So they outcompete the others. They may have technology because for setting industry or to flourish as a industrialist, you have to see so many things. So to my mind, it is a combination of both. And some are at the top level, and there are some others are also at the bottom level. If you see, this is the general reflection what you are saying, general perception. But we are looking when the parties are coming. We are looking what is the strength of. And there are some sectors where few people are in a higher market share, higher concentration, and others are very minimal. But there are other sectors also where you see market is one way evenly distributed. So to outrightly say that it is for all sectors may not be right, but some sectors it is okay, and that is natural. Thank you.
Okay, thank you, sir. So now we are towards the business end of this exciting and very interesting colloquy. So I am now requesting our vote of thanks to our research scholars. Please, can you, Sayanika, Dr. Miss Sayanika?
Yes, sir.
Thanks. Yeah.
Yes, sir, I'm here.
Can I just give a concluding remark before the vote of thanks? Rajiv?
Yeah, yes, sir. Yes, sir. Please go ahead.
Actually, I am very happy for the inaugural colloquy. Dr. Raut highlighted the importance of regulatory oversight and the role of Competition Commission of India in maintaining fair and competitive markets. Dr. Maji brought out the economic logic. He elaborated what is the role of the government, and the government failure, market failure, asymmetric information, then the Pigovian logic. So many, economic theories came to the picture. Then he talked about, how market power is, that in the new age business after globalization, then it is not to control the rise of monopoly, let it be. But abuse of monopoly should be restricted. So that is actually a fine take of this discourse. Then some questions remained, like when monopoly increases, then we know as students of economics that deadweight loss increases. Then how to keep a fine balance between this minimization of a deadweight loss. So for which economics always argue that there should be competition so that this will be reduced. Then Competition Commission of India is there, I think, to enhance competitiveness in an economy. So actually, this inaugural colloquy, set the, guidelines what we can do in future, and the future colloquy which will come. We are planning to bring this every month, and we can link some topics accordingly. And we hope scholars like Dr. Raut and practitioner economists like Dr. Maji, they will be associated with the department in these future endeavors also. So we are really benefited by your presence. So this academic journey seeks your well wishes and blessings in future. So with these words, I express a deep sense of appreciation on my behalf, on behalf of my department. But the formal vote of thanks will be, proposed by Ms. Choyanika, a research scholar of the department. Thank you, Dr. Rajiv. You can hand over to Ms. Choyanika.
Fine, thank you.
Yes, thank you, sir. So I would like to extend my sincere gratitude to our honorable guests for such an insightful and wonderful session on Competition Commission of India, and for giving us all detailed knowledge about the regulatory bodies, policies, impacts, and importance of competition in the market. Thank you, sir, Vidyadhar Maji and Dr. Chintamani Raut, for your valuable time and inspiring us all with your words and knowledge. I would also like to thank our professors, Professor Nayak and Rajiv, sir, for organizing this session successfully. Lastly, I would like to thank the students and research scholars for your enthusiastic participation in this event. And I am sure that this session was very effective and beneficial for you all. So I thank you all. And with that, we are concluding our session for today. Thank you.
Thank you, everyone.
Thank you. Namaste to everyone.